Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources.
Welcome to the Forest Resources Committee podcast. I'm Andrew Keene.
And I'm Dylan Solfrank.
In this episode, we're talking with Chris King about tribal forest management, and specifically the federal government's trust responsibilities in managing forests and natural resources on tribal lands. Chris King is an attorney at the Whitley Law Firm specialized in federal Indian law, government relations, and complex litigation, and is a former Department of Interior attorney. Welcome, Chris.
Thank you, Dylan and Andrew. I appreciate you inviting me here to speak today.
To start, why don't you give us a brief overview of the trust relationship between the United States government and federally recognized tribes to frame today's discussion for our listeners?
Sure. Well, in the lead up to our chat today, I had the opportunity to listen to your earlier conversation with former Solicitor Leshy, and I really appreciated hearing his framing of what it means to, have public lands today, how they're managed, specifically forests. And I thought it was interesting the way he began his talk to explain and make the audience realize that, it's a fact that every acre of land on this continent once belonged to indigenous people. For purposes of his talk, he necessarily had to fast forward a little bit to get to where the kind of genesis of modern public lands law begins in the late 1800s. So I think to kind of get to your question, where does this idea of a trust relationship and trust obligations begin? It's filling in a little of that gap that he had to jump. So when he was talking about the country expanding westward after the Revolution and having to come up with a way of dealing with what became federal lands, we're talking, and if you divide the body of federal Indian law into eras, immediately after the Revolution, we're talking the treaty making era. Prior to the English crown, French crown, Spanish crown, they made treaties with the Indian nations that they engaged, and this was necessary because they were engaging with, at that time, co-equal sovereigns in terms of both people, military prowess. So they had to engage on a sovereign to sovereign basis. That's the way European nations were used to dealing with each other. So that's how they would deal with tribes. And in those treaties, as moved westward, they were initially, you look at the earlier ones and they have language where they talk about peace and friendship. Essentially, we're going to stop fighting each other and killing each other, and we're going to come to an agreement on whose area is what and who keeps what. That's basically the early treaties in a nutshell. And in those instances, tribes agreed to, for the most part, give up their usual and accustomed territories where they would roam, live, hunt, fish, gather, and stay on what was acknowledged to be the tribe's land. As the decades of the 19th century progress, more and more Americans wanting to move further and further west. You come into the next era, generally known as the removal era. Eastern tribes are moved westward past the Mississippi. Many of them are parked in Oklahoma. Indian territory at the time became the state of Oklahoma. And as we get further west, the United States gets to a point of not necessarily needing to treat tribes as co-equal sovereigns anymore. This is largely due to their military advantage. They had the guns, they had the power, they had the people. Eventually, they would, with some notable exceptions like the Chiricahua Apache in the Southwest, who managed to hold off the United States cavalry for quite some time. Eventually, the United States got what it wanted. And what that means is, if you think about, the first treaty with a particular group having a massive swath of land where a tribe remained, subsequent treaties carved that down further and further. That's where the term reservation comes from. There's a large body of land, new treaty, where a portion of that prior larger area is reserved for the tribe's exclusive use and occupation. Now, what comes in that reservation, often this is spelled out in treaties, but what developed is that everything within those boundaries was, a asset, if you want to use more modern trust terms, an asset of the tribe. The minerals, the timber in our cases, those were reserved for the tribe along with the land. You get to the end of treaty making, 1870s, where it moved towards a trend of executive orders and congressional acts, further limiting and defining the scope of what tribes would retain. And that's really the genesis of when you think of modern day reservation boundaries in Indian country, you're looking at decisions that were largely made in the late 19th century by executive orders and congressional actions. And this is kind of where former Solicitor Leshy picked up, where you have this body of public land laws developing, because we now have public land because we solved the Indian problem. They are in a confined, reserved area, and we have justified all that through our legal machinations of treaty, statute, executive order, and now we have all this extra land that is the federal government's land. And as I said, this gets to timber as a trust asset, everything within those boundaries was considered a trust asset and resource of the tribe. So it's fairly common to people who aren't deeply steeped in Indian claims litigation history to hear about this history and ask, well, it sounds like tribes had a lot taken away from them, oftentimes unfairly, unconscionably, getting pennies on the dollar for lands that they lost, having to sign agreements and agree to statutes at literally a gunpoint. So what can tribes do about those historical dispossessions, their losses of their lands and resources? And that's a question that, Congress was kicking around extensively in the middle of the 20th century. And by 1946, they decided, you know what, we're ready to be out of the Indian claims business, because prior to 1946, anytime a tribe wanted to sue the United States in the Court of Federal Claims is where you sue the United States to get money damages, special jurisdictional acts had to be created to waive the United States sovereign immunity in order for a tribe to bring a suit against the United States. And it's time consuming, inefficient to have this sort of piecemeal jurisdictional statutes. And many tribes did this. Beginning in the late 1800s, there are many cases in the Court of Federal Claims predecessors of tribes that had the ability and funds to hire attorneys and lobbyists to get statutes passed for a jurisdictional act to the United States. 1946, Congress says, you know what, we're tired of that. We're going to give every tribe in the United States, one last shot to sue us for anything that happened before 1946, without regard to statute of limitations, without regards to laches, defenses, or anything else the United States would normally use. This is your chance, tribe. We'll give you 5 years to come file your suit. And that was known as the Indian Claims Commission. There were hundreds of dockets from tribes all over the country for all manner of things. One key point, though, is the remedies that were envisioned and written into the Indian Claims Commission statute. Congress also decided, well, we're going to clear the books of Indian claims. We're not going to give land back. They were adamant that land was not going to be given back to tribes. By that point, you'd already had the Indian Reorganization Act of 1934. There were already statutory mechanisms where tribes could get land back, but that wasn't the point of this. The point of the Indian Claims Commission was to put a dollar value on things that were lost, whether it was land, whether it was resources. The United States, they weren't going to give land back, but they could find a way to value something and pay the tribes money. And so the results of all these ICC dockets were judgment awards in favor of tribes. And in part of the settlements for all those cases, tribes, and then, this was by statute, they were forever disclaiming anything that happened before 1946 that the United States did. So this kind of brings us into the modern era, 50s into the 60s, 70s. Part of that era was, the termination, known as the termination era, where Congress thought for a while, hey, maybe it's better for tribes if we cut them loose. They're no longer under federal guardianship, and we give them their land and fee and let them manage their own affairs. policy was soundly rejected by the 1970s and the Nixon administration. But you then start to see Congress more directly legislating to kind of define the scope and guardrails of the United States obligations to tribes in various areas. And one of those, why we're talking today, is timber.
Thanks for taking us back in time and helping us understand the federal government's treatment of tribal assets, so to say, over the course of the 19th and 20th centuries. Moving ahead now to the current statutory framework. The National Indian Forest Resources Management Act of 1990 is the primary federal law setting out the legal framework for the management of forest lands held in trust for federally recognized tribes. How does the act shape obligations as between the tribes and the federal government? What duties does the federal government owe to tribes in its capacity as trustee?
What the statutes like NIFRMA, it's one of those hard acronyms to have really roll off your tongue, and the associated regulations for forest management, as you'll see demonstrated when we talk about some of the cases later. It's this idea that Congress deciding that something is becoming an obligation because we're gonna codify it and we're gonna prescribe the metes and bounds of what the United States shall do. And I think that's one of the, kind of key distinctions if you want to talk about what's the difference between in the Indian affairs context, Indian law context, what's the difference between the trust responsibility of the United States to do something and a trust obligation to do something. And I think if you want to think about a trust responsibility first, it's easiest to conceive of this in terms of the historical relationship of the United States and what it has done to tribes, the situation that has put tribes in terms of land tenure, status, etc., certain historical moral obligations to do the right thing because we hold ourselves as a morally upstanding country that does right by its citizenry. And this relationship that the United States has taken upon itself in its historical dealings with tribes. But the difference between a responsibility and an obligation is in how it plays out in statutes and regulations like this is the difference between may and must, should and shall. It's thinking about the trust responsibility. Yes, the United States should do these things. The United States may do these things for the benefit of tribes and to assist tribes because it's the right thing to do. In contrast with the United States shall or must do certain things because a statute or regulation says the United States must do that thing. And that's the hooks that come out of a statute like NIFRMA and its associated regulations. I think when I was in the solicitor's office, I was there for a little over a decade. I worked in the Division of Indian Affairs, in the Indian Trust Litigation Office, doing a number of different things. I had the opportunity to work on a solicitor's opinion with former solicitor Hillary Tompkins. And that opinion was on the trust responsibility. It was January 2017. And it's one of those solicitor's opinion that has stood the test of time. It may be familiar with some in this audience that are familiar with interior solicitors' opinions, but they tend to get reversed and withdrawn. But this one is held because it's a solid statement, and it really draws out some of these distinctions. Of course, giving a snapshot in time of the litigation history as of 2017. Lots of cases have happened since then to kind of shift that. I'd encourage the audience to go check out that trust relationship responsibility opinion, and it talks about this distinction. And like I said, that distinction is what should the United States do because it's the right thing, and what must it do because a statute or regulation says it does. And for purposes of these cases we'll talk about in a minute, where the fights are is tribes trying to take advantage of in situ common law fiduciary principles of the duties that a trustee owes a beneficiary alongside what a statute or regulation says, and saying the common law trust principles alongside what the statutes and regulations say, create enforceable obligations. And by enforceable obligations, at least in the context of a case filed in the Court of Federal Claims, that means one, the breaches of which are redressable in money damages. And so there's a whole body of case law that underpins every breach of trust action. And they all kind of boil down to, do the statutes and regulations establish enforceable duties, i.e., the statute says the United States must or shall do something. Did the United States do that thing? And then secondly, if we're in the Court of Federal Claims, is the remedy for the breach of not doing that thing one that sounds in money damages? Because if you don't check all of those boxes, then your claim will get kicked from the CFC. And that's kind of the whole, over the last 30, 40 some odd years, that's how this body of law has evolved to where we are now, to suits like, the Yakimas and the Colvilles cases in CFC over issues with their forests.
Thanks, Chris, for walking us through that. You mentioned some case law, so let's turn to the courts next. What type of management actions, or lack thereof, are typically the subject of breach of trust claims over forest management and fire issues?
Sure. So I think where the best place to start with this is appreciating, the Mitchell decisions. They're foundational for all breach of trust litigation, but pointedly for us, it was also a timber case. And it kind of demonstrates, these began in the 80s, the Quinault Reservation, shows first kinds of things that tribes were trying to hold the United States accountable for management of these trust assets. And there it was some basic claims surrounding how the United States was managing the forest. Was the United States, because to the extent the United States was basically the broker for sale for the asset, how were they or were they not obtaining the best fair market value for the timber? How are their management decisions meeting up to sustained yield principles in a way that would make it the most profitable? Road work. I mean, all these kinds of things that, taken together, back to these kind of common law trust principles. If the trustee is responsible, has this asset, a trust corpus, you have the beneficiary, and the trustee has to act in the best interest of the beneficiary. What does that mean in a forest? And what does it mean for the disposition of that resource? And, it was those couple of things that I just mentioned. These cases came about prior to the enactment of NIFRMA, which I think, part and parcel reasons for a statute like that is seeing the examples of, like, okay, Congress realizing maybe there are some more concrete things that we can do and guardrails that we can constrain and lead and direct the United States management of these forests to more better fulfill that obligation of the United States to, both manage these forests in a sustained manner, under sustained yield principles, and make sure that the beneficiary is getting fair market value. And what Mitchell shows us, or showed at the time and what was after, is like, when the United States doesn't do those things, and this will be a recurring theme that I talk about again when we start talking about fires, you can't regrow a forest that's been cut down and resell it again. But if, in these contexts, you can point to decisions that were made, affirmative decisions that were made, that led to that resource being sold undervalued, you can put a dollar value on that, and you can hold the United States to account for that. And that's what Mitchell shows us. And of course, a much broader doctrinal history of what's an enforceable trust obligation that's been, applied across all manner of subject matter for trust. But yeah, as you see, the kinds of actions, in the modern era, management more complex, forest management's more complex, and things that come out of, the evolved regulations, evolved statutes, how forest management plans are developed for the long-term management of an asset. We'll talk about the Yakima case here, and how the first Yakima suit was over a forest management plan, and whether or not there were enough, they were enough, essentially enough board feet of timber was coming out of that forest and being taken to market.
Now that you've provided an overview of the legal underpinnings and general processes involved in federal Indian trust litigation, let's discuss a few specific examples. Could you tell us about the trust litigation relating to the Colville and Yakima fires?
Sure. So pending in the Court of Federal Claims right now are three different cases involving forest management fire claims brought by tribal entities against the United States. The one that kicked it off was Yakima, and their first complaint was calling into question some of these sustained yield forestry management obligations that we were discussing. Were adequate timber harvest levels met? Were the timber sales properly administered? Was the forest being managed for long-term productivity and economic value? That case went through a motion to dismiss. The decision after the motion to dismiss kind of reaffirmed, applying Mitchell, that statutes and regulations here did establish these enforceable obligations that that tribes could bring and would survive a motion to dismiss. So that one about timber harvest and sales, that's what you refer to it, Yakima one. That was the one that was filed first. They then filed another action in the aftermath of some, there were a number of, as we've all seen in the news, forest fires ravaging the Pacific Northwest, over the last decade. Happens, it's almost by yearly basis. The second action that Yakima filed was specifically related to how these fires decimated their timber stands. And, fair, obvious question, like, well, the forest fire is an act of nature. How can the United States be responsible for a forest fire burning down trees? That's what forest fires do. Sometimes they're started by lightning strikes, and it just happens. Why is the United States on the hook? Or why could they be on the hook? And I think what the second Yakima case shows is, while that may be true, fires are naturally occurring phenomena. They always have been. They always will be. It's particularly, climate change, and it's not like these fires are going to stop happening, and that there's anything the United States can do to make forest fires stop happening. But what the second Yakima complaint shows is, well, there is something that the United States could do. And I think that's what they are trying to demonstrate in their complaint, is to the extent management decisions created a scenario on the ground. I mean, this is, of course, I'm trying to boil down a very large complaint with lots and lots of details into a couple sentences, and this is my best elevator pitch on what these fire cases are about. Is there are management decisions that the United States Bureau of Indian Affairs was responsible for that set the conditions on the ground that were present when these fires started. And, kind of the underpinning of Yakima and later the Colville's subsequent case. Colville filed third, but it was very similar to Yakima 2 in the sense that, similar theories about fires. And what the complaints alleged is that affirmative management decisions for things like fuels management, slash pile disposal, fire preparedness, fire suppression, roads, the combination of these things that were the BIA's obligation to do, set the stage such that when the fire happened, the fire burned more timber than would have been burned if better management decisions had been made. I.e., there is less slash out there to burn. I.e., there are adequate roads maintained, fire service roads maintained throughout the forest, such that when a forest starts, the people responding to it can get to it more effectively, et cetera, et cetera. And that's kind of the simplest way to describe what these claims are about, that the United States could have done better to manage the forests such that when the fire occurred, less would have burned. As I mentioned earlier, you can't regrow the forest that's burned down, but you can put a dollar value on it, because if there had been, if not as much had burned down, that's more that a tribe could have taken to market, gotten a return on. So what these, again, Yakima 2, Colville went through a motion to dismiss, largely survived a motion to dismiss with a few refinements. And now the two of them, these three cases are in discovery and likely headed to summary judgment proceedings next when discovery concludes. But I think one of the imports of what Yakima and Colville have done with these cases is providing somewhat of a roadmap to other similarly situated tribes that have experienced fires. And when I say a roadmap, I'm talking about developing a complaint, collecting the types of factual allegations. Because if you compare the two complaints, they're citing the same sorts of materials, factual materials, as the basis for their complaints. These are things like agency produced reports on, forest management plans, after fire incident reports. It's a fairly translatable body of factual sources that went into underlying their claims. And those same types of documents exist all throughout Indian country, that tribes that have forests, that have fires, have the same general universe of the same types of documents. And so I think what they have done is somewhat shown the way for a complaint that will survive a motion to dismiss, because that's what they did, and that's where they are now. They've survived a motion to dismiss. They've shown Indian country what that complaint looks like.
Thank you, Chris. You mentioned climate change, which is driving increasing wildfire risks, particularly here in the West. On top of that, we're also facing fluctuating regulatory schemes, and those together make these unprecedented times for tribal forest management. How can tribes employ breach of trust litigation to better meet these changing regulatory and ecological circumstances?
It's probably best for thinking about resorting to litigation as the last resort. Breach of trust actions are by design, by their very nature, they're retrospective. That they look in the instance of these complaints with Yakima Colville, they're talking about activities, that fires that happened, agency decisions that happened years and years ago. But to the point of your question, in what's happening now, what will happen with increasing wildfire risks, of the menu of options or tools that tribes have in their toolkit, I think they also have to appreciate that they're stuck with their trustee, and they have to work with the United States. They have to work with the BIA. They have to work with the Forest Service. That relationship's not going anywhere. And it's difficult to, in the trust responsibility opinion that I referenced earlier, acknowledges this, that it's difficult for the United States and tribes to have the most robust and productive partnership to accomplish mutually goals that are of mutual interest and benefit if they're constantly in a litigation posture. When you're in a litigation posture, it's difficult for tribal leadership to speak as freely on certain things because their attorneys tell them not to, because it's in litigation, and the United States doesn't always necessarily want to talk about certain things if it's in litigation. For better or for worse, tribes have to continue to work hand in hand with their trustee. And if not to disparage all us lawyers out there, if the two are perpetually in litigation posture against each other, the only ones who win are the lawyers. The lawyers are always busy. But that, at the end of the day, again, not to discredit everything we were just talking about, like why these suits matter and what they can accomplish, it's always going to be important to recognize that when you can't regrow the forest, then a dollar value can be put on it. And the only way to, reclaim those losses is litigation, then there's definitely a place for it. And that's how this body of case law is developed. That's why these jurisdictional statutes exist. But, I think going forward, policies will change from administration to administration. That's a given. I think now this administration is trying to do things, to work cooperatively with tribes. Just reading recently about, very interesting sounding co-stewardship agreement between the Forest Service and Cow Creek Band of Umpqua to sharing responsibility, co-managing the resources. And ultimately, when the types of catastrophic climate disasters, they don't pay attention to state borders, don't pay attention to reservation boundary lines, don't pay attention to the jurisdictional scope of who is managing what. It's the fire is just going to burn the trees as far as the fire will go. Then, it really behooves tribes in the United States to find ways to work together as best as possible. But give back to the, recognize us lawyers and what we do in this role. There will still be a place as a last resort, if needed, to make tribes whole for those losses that in reality only the United States can satisfy.
Thanks, Chris. It is a helpful perspective to remember that collaboration is preferable over litigation. Looking ahead, when litigation is necessary, what practices can tribes use to bring successful breach of trust actions? Do you see any trends in the federal government's handling of such claims that may be worthwhile for tribes to consider?
As I mentioned before, there are tribes out there that are thinking about this, thinking about, the recent history of what's happened on their lands and with their forests. Go review the Yakima and Colville complaints. Those are templates of best practices in terms of what will keep you in the courtroom. If the courtroom is where you need to be, and tribal leadership has determined that the best use of resources, preservation of relationships, and moving forward productively, and litigation is where they need to go, then I think the Yakima and Colville complaints have provided a good template for those that want to consider exploring litigation. It's a decision that should not be entered into lightly. Those cases have been going on for years now. Litigation's expensive, discovery's expensive. And then, when you get through discovery, you're barely halfway there, to the extent that things go to summary judgment or trial and appeals. But just as a baseline, thinking about, hey, do we have a claim? And can our claim fit neatly into a vehicle that belongs in the courtroom and will stay in the courtroom? Pass the motion to dismiss. I think the Yakima and Colville examples are very good for that. Trends, the way federal government's handling claims, I can't exactly speak to the trends that are evolving, having been away from federal service for the past year. I would say to that, watch the news. And you will see and watch how these decisions play out.
Well, thank you very much for your time today, Chris. The last word is yours. What would you like our listeners to walk away with today?
What these kind of cases in this issue of forest resources, the duties and obligations and responsibilities the United States have taken on, the future for this area is finding, an ideal and effective alignment between those responsibilities. And I'm talking small r responsibilities, the United States should do things because it's the right thing to do. And implementation, actually doing the thing where it can be done, regardless of if a statute actually commands that thing to be done. Because of course, it's always a defense at the end of years of litigation. And the Navajo Nation experienced this quite profoundly in the Arizona v. Navajo decision that went to the Supreme Court, where at the end of the day, the body of precedent tends to lean more in favor of the government on what's the enforceable money mandating duty that you can take the government to court for. But that doesn't necessarily mean that interests can align. The co-stewardship agreement I just referenced, Cow Creek example of, that those things can align to produce more mutually beneficial outcomes. The opinion discusses this as well. And I think what we're going to see in the years ahead, because as I mentioned, fires are going to keep coming. The issue I really see is putting aside the time and resources that tribes would spend to fight this in court. And again, sometimes they need to. How are the United States, as the trustee and tribes beneficiaries, going to reach a place where they can coexist cooperatively to achieve these mutually beneficial goals? This administration is making an attempt to with certain things that it does. I say certain things that it's doing. The next administration will likely change some of those things. Maybe not all of them, but definitely some of them. I'm glad we were able to have this conversation today. I hope it informs your listeners. I think this is a really interesting series, and I'm looking forward to seeing where y'all take this next. So thank you for having me.
One final thank you to you, Chris. Your knowledge in this area is clearly very deep, and we appreciate your time.
Thank you.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/Envira. Please check where you found us for future episodes. Thank you for listening.